When is a contract a contract? Getting into offer and acceptance. Today on the podcast.
This is the Wedding Industry Law Podcast, a podcast dedicated to wedding professionals that are just trying to keep it legal. And now, your host, Rob Shank.
Hey out there, welcome back to the podcast. Glad you could join me. My name is Rob. I'm going to be your host. We're going to be talking about all things contract formation and things that you can be doing to help protect your business from being in a no man's land of not having a contract when you think that you have a contract. But before we get into that, I have one call to action for this program, and that is to please mosey on over to my YouTube channel, like and subscribe, but most importantly, subscribe. You don't have to dislike and subscribe. That's fine with me as long as you hit that subscribe button. I would be your best friend. Now, for those that don't know, that maybe are listening to this on their phone or what have you, the YouTube channel that we have at Wedding Industry Law is not just this podcast. There are other videos that are helpful to your business if you run a wedding business. So check out that YouTube channel. So I'm not just saying subscribe for no reason, but yeah, lots of information out there. So like and subscribe. If you have any suggestions for content for the podcast, please let me know in the comment section below, or hit me up on Instagram, or see me at Taco Bell or the drive-through line at Taco Bell, because I'm not going on a Taco Bell for now. But that's where you do it. Would love to hear from you. Really appreciate that. I do get to all the feedback. Not that there's a ton of it, but I will respond to it, or I will take it to heart. All right. With that being said, let's get into the episode. Now, I want to kind of educate everybody at the outset. I have talked about what a contract is on this program several times. And basically, you can boil down a contract as an exchange of promises. Okay, we all know that. I promise to give you $500. You promise to videotape my wedding. Okay, that can be a contract. It is exchange of promises. The issue today, folks, is when is the contract formed? Okay, when is there an actual promise and then in exchange for the other promise? Okay, so we are talking today about formation, kind of like Beyonce from however many years ago. I'm an old man. I don't know if anybody remembers that, the Get Information song. I was actually listening to that before I recorded this episode. Anyway, so formation. Essentially, in order to even get to the point where you got a contract, you have to have what's in the law you call offer and acceptance. So the offer is, essentially kind of the first promise. I'll video record your wedding for $500. That's the offer. Okay. Then the client, or whoever you make the offer to, probably the client in this case, but the client's going to say, yes, I will take that deal. And that's the acceptance. And then you have offer and acceptance, and you have the contract form. Now that's 1 year of law school condensed into about 30 seconds, offer and acceptance. So one of the first things I want you to understand is that offer and acceptance must mirror one another. So if I say, I'll videotape your wedding for $500, that being the offer, and instead of the client saying, yes, I'll take that, the client says, make it $300. That's not a mirror of the offer, and so therefore you don't have offer and acceptance. In reality, what you have is the videographer's offer, and the client has made a counter offer. Does that make sense? It's kind of like that scene in My Cousin Vinny where he goes to the bar to pick up the money from his Tia Leone. Not Tia Leone, that was David Duchovny's wife. I'm turning into my mom. Everybody's the same name. Everybody's face looks the same to me. Anyway, I digress. So that's a counteroffer. In other words, the offer and acceptance must mirror one another. There cannot be any difference between the offer and acceptance. So to that extent, if the client strikes through something, if the client wants something different or whatever, they have counteroffered to you. Does that make sense? Until there is an actual offer and acceptance that are the exact same, then you probably have not formed a contract. Offer and acceptance occurs in many different ways. Offer and acceptance can occur over the phone. Offer and acceptance can occur on writing, as you would typically do with your contract on paper or online, sending the email, whatever the case may be. You can form a contract in many, many different ways. Okay. But typically what happens is that your contract or your proposal, so the document that you show the client after you've had the back and forth emails for a week or a few days about what you're actually going to be doing, that document, the proposal or terms and conditions, whatever the case is, that you are sending to the client, that has the event date, how much it's going to cost, all that kind of stuff for them to sign off on, that is functioning as the offer. You feel me? That is your offer in terms of whether or not the contracts can be formed. And typically, acceptance is going to be the contract is signed by the client. That's the acceptance. The client hasn't changed anything in the contract. They're like, okay, sounds good. That's the proposal that we agreed on. I've signed on the dotted line. So that's your contract. The blank one that's not signed is functioning as the offer. Client signing that, functioning as the acceptance. Okay, that's when you typically would have a binding contract. Now, the point of this episode is I want you to avoid a no man's land. And that no man's land is when the rare times, hopefully rare for you, that you get a signed contract but no money, or you get that first deposit, first payment, first installment, whatever you call it, the first money, but no signed contract. What happens then? Well, typically, because your contracts probably don't address this, but typically you're going to be in a no man's land. Like that movie 1917, where they had to fight through the no man's land and get through all the mines and all the stuff. I digress again. I think that's my second reference. I apologize about that. But anyway, no man's land. Okay, so unless your contract addresses this, if you get a signed contract but no money, it's probable, although every state is different, every situation is different, and your contract is going to be, how it's written is going to dictate this. But typically, if you get that document that's signed but no money, then you probably have a contract, but you've acquiesced or waived timely payment of that first payment, which is no good. You want the money, right? If you get money but no contract, then you potentially have a contract. You probably have a contract, but what are the terms, right? You've got a client that's like, yeah, I'm throwing the money down, but maybe a week later you get the contract back and it's got strike-throughs in it. Well, is that a counteroffer? Because you've already accepted the money, right? So these are dangerous, I would call dangerous, legal no man's lands that you want to avoid. So how do we do that? We're 7 or 8 minutes into this podcast and getting to the meat. How do you avoid the no man's land of not potentially having a contract, or if you have a contract, not knowing what the terms are? And that's making payment and signed contract a part of the offer, such that the only way the client can accept is to give you both. That's how you can do it in the contract. Client, in order for this contract to be effective or whatever, again, don't quote me on this. I'm not giving you the exact words. I'm paraphrasing. So if this is something that you need to address, talk to an attorney about it. But it's going to be something along the lines of, in order for this contract to be effective, you must give me the signed contract, meaning that the client has signed it, but also that first payment. That way, you've made payment and signed contract a part of the acceptance process. In order to accept, you got to give me money and a signed contract. That's what that comes down to. That's how you are able to kind of sidestep the no man's land. Now, there are other things that you can do to manipulate the acceptance or try to incentivize acceptance as soon as possible. And that could also be, you can put in your contract or your proposal or whatever that thing is that you send to the client that they sign. You can make things vanishing. So, for example, you could say the prices provided in this proposal are only good for 10 days, 14 days, 20 days. That means that if they accept beyond that, or let me back up. That means if they don't sign that contract within 10, 20 days, the offer, poof, disappears. And you would need to renegotiate a new offer in which they would accept in a different way or in after that. So in other words, you can make the offer vanishing or the terms in that offer vanishing by a certain time period, such that they only have a certain amount of time to accept the offer as it stands in that contract. Does that make sense? So you can do all kinds of crazy stuff with your contract in terms of how the offer is made and how the offer eventually is accepted by the client. Okay. Offer and acceptance, we got it. A+. Let's move on to the next thing. Next thing is this. Do you have to countersign? Do you have to countersign that in order to have a contract? Well, now, again, it's going to depend on the wording of your contract, maybe your jurisdiction, but typically not, because your document. Now, again, there are a million situations in which countersigning a contract is required. So, for example, if there's a settlement agreement in an injury case and there's two attorney teams on both sides negotiating back and forth, the one side and the other side, that shows that both have agreed to the terms that are exactly on that page. This is not that type of situation. This is not a situation in which you've got billion-dollar companies negotiating something over the course of a year and both sides need to sign. We're talking about a videographer, a florist, a planner, in which the proposal is the offer. So as the professional giving that proposal, giving that contract with those terms and obligations in them, it's the client that by you're telling the client, by signing this, you are accepting. That's the offer and acceptance that forms the contract, such that you could countersign, but the countersign is irrelevant to the fact that the client's already accepted your offer. So I've got clients that do countersign the documents in the first instance where there's been back and forth negotiation, maybe the other side has a lawyer. And in the other instance, just to make the client feel good and to make sure that, that everybody agrees to what the terms are. However, is it necessary? In most instances, it is not. You already have a contract when the client signs, i.e. accepts your offer. Hope that makes sense. So, some of that stuff can kind of get dicey, but that's typically how the law works in terms of sign, countersign. So what about e-contracts? Are e-contracts valid? Yes. So I believe at this point now, every state has a statute dealing with the legitimacy of e-signed contracts. So when when you're at Publix or Kroger or Ralph's or whatever you call it in your state, Piggly Wiggly, Winn-Dixie, I don't know. You sign the little thing when you pay back by debit or credit. Same concept. Okay, that's an electronic signature. It's the same concept when you use DocuSign or whatever, emailing. These things are now universally accepted as legitimate. You don't have to have an ink signing on the contract any longer. So in terms of e-contracts, I would banish that from the worry in your little mind. No worry. I'm just kidding. Not little mind. You don't have a little mind. I have a little mind. So don't worry about that. E-contracts universally now accepted, as valid. So don't worry about that in terms of the validity of the contract. So again, not to digress again, but the idea of the problems behind e-signing or the idea behind countersigning your own contract, a lot of times it has to do with whether or not a person has signed the contract as opposed to whether or not there's a contract at all. It's like, I didn't sign that. That's not me. I never met you in my life. What are you doing coming here videotaping my wedding? So a lot of times that's really not the issue. So as a wedding professional, I wouldn't worry too much about that particular predicament. The final thing that I want to address is, and as strange as it sounds, I do get this question fairly commonly, fairly often. It's a fairly common question that I get, I should say. Do you have to notarize contracts? Do you have to notarize contracts? The answer is no. In order to form a contract, you do not have to have it notarized. Again, I mean, you could if you wanted to. Essentially, the notary is verification that the person that has signed it is who they say they are. So the function of the notary is to go, all right, give me your driver's license. I look at your driver. Okay, you're John Smith. Okay, I believe you're John Smith. And when you sign that and you put John Smith, okay, I've witnessed that. By the power vested in me by the county clerk's office, I witnessed John Smith sign this document. I'm stamping my notary seal on it. If you buy a house, maybe there's some laws that say that it needs to be notarized. If you sign a settlement agreement or something like that, maybe you probably have to have it notarized. But by and large, your wedding professional contract does not need to be notarized because there's typically not going to be an issue with people saying they are someone that they're not, that they're saying that they're someone that they're not. That's typically not going to be the issue. So you have to notarize something? Probably not. Now, that's going to cover it for this issue. So the long and short of it is this. Make sure that your contract, your proposal, makes or dictates the way that the client accepts the offer. That is to say, make sure that your contract addresses, I want the contract signed and I want the money in order for you to have validly accepted my offer for this contract to be formed. Okay. Second thing is you can countersign. It's not necessarily necessary, but again, get the advice of your local attorney. Finally, e-contracts, okay. Notary, not so much necessary in today's day and age. So I hope that this more or less short and sweet episode, hopefully it's short and sweet, was helpful for you. I hope that this cleared up some issues that you may have been having. This issue was brought to my attention by a listener of the podcast, so shout out to them. Again, like I said, I could try to get to most all comments that I get. If you are enjoying the content of these episodes, which are weekly, coming out on Mondays, then please feel free to like and subscribe wherever you get your podcast from. And I think with that, we'll see you next week.
Thank you for listening to the Wedding Industry Law Podcast. This podcast is intended for general information only. Nothing in this podcast is intended to be legal advice. Do not rely on this podcast for your legal matter. Instead, consult an attorney in your area. Thanks, obrigada, até semana que vem.